Welcome to today's program titled Compliance Chatter Virtual Meetings April Session. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the program by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE or SHRM credit for this webinar, attendance verification codes will be read later in the presentation. Please write these codes down as they will not be reread and are required on the credit request form. During the presentation, you will see a slide with a QR code that you may scan to access and submit your request for credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Masa Ali-Asghari. Masa, please go ahead.
Hi, everyone. Thank you so much for joining us on our April session of the Compliance Chatter meetings. I will be your the moderator for today's session. I sit in our downtown LA office here at Seyfarth, and I practice both the business side of immigration, your visa and benefits, as well as support clients through compliance matters as well related to I-9s, audits, investigations, Department of Labor, Department of Justice investigations as well, where they intersect with immigration. We're really thrilled to have you join us today, and we have an exciting lineup of topics and a panel of experts ready to share some of their latest insights on navigating all of the things that we're hearing about and seeing happening with the Department of Homeland Security agencies as they relate to worksite efforts and enforcement actions. And now let me introduce you to our speakers, and I'll let Leon kick it off and introduce himself as one of our speakers today.
Sure. Good afternoon and good morning. I'm Leon Rodriguez. As you can see, I'm a partner in Seyfarth's Washington, D.C. office. I am a member of the immigration group and a co-chair, along with Dawn, who you'll meet in a moment, of the immigration compliance and enforcement specialty team. I joined Seyfarth after having served as the director of U.S. Citizenship and Immigration Services, USCIS, probably to most of you. And I spent most of my career as a state and federal prosecutor.
Thank you, Leon. My name is Dawn Laurie. I do co-chair the Immigration Compliance and Enforcement Specialty Team out of Washington, D.C. I've been practicing in this area for almost 35 years. Hard to even say that. And while in a past life I did immigration visa work for 10 plus years, I focused only on Form I-9, E-Verify, electronic I-9, all those types of good things. And I'm really fortunate that Seyfarth has allowed me to kind of carve out my practice in this area. And much like Masa and Leon, we work on representing employers that are involved in civil and criminal workplace enforcement actions, investigations. It could be with the Homeland Security at ICE, or it could be with the Department of Justice or the Department of Labor. We work on diligence and M&A work and other corporate transactions. And again, also do day-to-day advice and counsel. Have a particular specialty in electronic I-9s, and I'm really pleased to have John join us from one of the various vendors that we work with, not recommend, but work with. John, thank you again for joining us. Go ahead.
Absolutely. Good morning and good afternoon to everyone. My name is John Mazzio. I am the Senior Director and Associate General Counsel at a company called Vertical Screen Incorporated. We provide background screening, drug testing, and of course, I-9 and E-Verify services through one of our many business lines, the latter being I-9 Success. In a prior life, pardon me, I was a trial attorney with Immigration and Customs Enforcement, handling I-9 and E-Verify and Worksite, along with a host of other duties for Pennsylvania, Delaware, and West Virginia. That's where I started my career and then came here. I also serve as vice chair of the Verification and Liaison Document committee with the American Immigration Lawyers Association, and love to provide the commentary and thought leadership on these issues with my fellow panelists today.
Wonderful. Well, thank you all. As you can see, we have a lot of folks who have both government and private experience. So this will be a really helpful session for all of us, hopefully. Here's a quick overview of what we'll be covering today. Going through the current DHS landscape, we'll look at increased enforcement trends and what's on the horizon, talk through some of the visa terms, revocations, and impacts that we're seeing on the current administration's policies and actions related to green card holders as well. Something that's on everybody's top of mind, how some of the various programs related to temporary protected status and humanitarian programs are being impacted by current policies. And then we'll dive into some proactive compliance planning and really talk through how can we take action now to be prepared for what might be coming down the pipeline. And with that, I'm going to hand it over to Dawn and to talk to us a little bit about the changing landscape of enforcement.
Well, thank you. It really has been a roller coaster since January 20th. As I said, I've been in this space for a really long time, and I've seen the ups and downs. I started right after the Immigration Reform and Control Act was passed, and have lived through INS investigations and some of the largest worksite investigations in the past. Just yesterday, ICE announced in their worksite enforcement news insights some of their statistics. They said that they were arrested over 1,000 illegal alien workers without employment authorizations since January 20th, and they provided information on the Form I-9 inspections that they're doing, and they discussed that. I think it's interesting that they provided the $1 million in fines. Basically, I think they've said they've subpoenaed the business records of about 1,200 businesses. That would be the notices of inspection that employers are receiving for their I-9s. And they said, as part of our review, we proposed close to $1 million in fines. I think their data might be a little bit behind, because I heard today from a colleague outside of Seyfarth that one of his companies received a notice of intent to fine of over $4 million. So folks, this is pretty serious. The government has increased their notices of inspections. That is just one tool in their toolbox that ICE uses. It's a way to take a look at whether or not you have unlawful workers, and also whether or not you have followed all the paperwork requirements to complete the work authorization and verification of identity of all workers that are hired after 1986. So they are on the rise. What we're seeing in the field is a particular rise of investigations and notices of smaller businesses, along with some of the medium and larger size. We never really saw as many small types of investigations as we've seen now. And John, I know you have your finger on the pulse there. Let me stop there. What are you seeing in terms of the types of businesses? I know we talk about our targeted industry and the size.
Yes, so it's been a little bit surprising to me, yet not surprising, because a lot of the targets that I've seen, especially of those, the notice of inspection plus, where they go and arrest a body or they detain someone, are really the smaller businesses, bakeries. I saw 2 weeks ago there was about 40 non-citizens apprehended in a full-on operation out in Washington State. I have yet to see, knock on wood, sort of the large-scale issue. The large-scale action. But just as I remarked to someone this morning, I think that's coming, because at the end of the day, we are only roughly 3 months in on this administration, and it takes time to build that full-scale worksite operation, coordinate the logistics, build your probable cause, build your rationale for going and getting the search warrant and executing it, and then building out that plan to execute it, maybe across multiple locations across multiple states with different agencies involved.
Yeah, let's talk about that for a second, because right now, Leon and I are doing this, on a daily basis. We're seeing different types of ICE, I'll call them knocks, touches. And we have not seen, you didn't use the word raid, but we've not seen a full out raid. To give you just some perspective, in the last Trump administration, there were like 22, I believe, actual worksite large raids that were facilitated, that took, my understanding, 8 to 12 months for each of them to logistically be planned and executed. We haven't seen one of those where they come in, with the helicopters and all sorts of law enforcement, and it's a very large operation. We've seen smaller, right? We have seen where other agencies are going in. And by the way, in terms of what we're seeing in the field, that is one thing we're seeing. We're seeing cooperation with other agencies. So when you see FBI and you see the jackets, when you see the ATF, when you see the DEA, and you see all these folks, they have been marshaled by HSI or by DHS to come in and to support. We're also seeing, folks behind the scenes. There's a lot of FBI analysts, I understand, that are looking and helping and supporting with the notices of inspection. So again, that's going to be at the top. That's going to be worst case, and I don't believe we've seen an all-out raid like that. Next thing underneath that is where we see ICE coming in, where they are bringing in a judicial search warrant and they're looking for someone, or they're looking to pick up individuals, and you are going to, it might feel like a raid, but it's a little bit smaller. Right under that, we'll have like maybe what we're calling the knock and talks, where they come in and they don't have a judicial warrant. They want to talk to you. They maybe want to discuss a particular employee, or they may want to ask about your business. Underneath that, you're going to have that notice of inspection. So I went from, the worst to just baseline notice of inspection. It is really important for you all on the call today to have a plan of action, whether you have 5 employees, 500, or 5,000. It is important for your folks to know what they can and should be doing when employees, when ICE comes and does knocks. In terms of other, because I just want to be careful on time, we are also seeing, and John, you kind of alluded to this, the start of criminal prosecutions, and our contacts over in the government have been very clear that those are going to increase. So we're going to see more of the different types of warrants that will allow for ICE to come in and not necessarily be looking for a particular person, right? We have something called Blackie's warrants, where they're coming in, they have reasonable cause, they are judicial warrants, but they may not name Dawn or Massa or John or Leon, and they can come in. There also may be Rule 41 warrants and all these types of good things. Your folks should be familiar. So criminal prosecutions are on the rise. You mentioned a bakery, John. You're probably talking about Abby's Bakery in Texas, where the owners also provided an apartment for the employees, and so now they're being charged with harboring.
So to ask kind of anyone really at this point on the panel in terms of the other observations, can we talk a little bit about what we're seeing in terms of state and local actors, in terms of sanctuary cities, what we're seeing there and what's happening?
Yeah, John, why don't you start?
Yeah, so I'm really seeing a rise in those 287G agreements, and those sort of flip a switch for
And John,
me.
for those who are not aware, can you
That's where the local authority will join up with ICE and agree to turn over certain individuals, or agree to really act as the sort of extended arm of the agency. And what I was shocked to see, I think it was last week, is that there are certain universities that have police forces that are signing those 287G agreements. And that, buttressed with the rise in student visa revocations and rescissions, is really interesting. And how that plays out, in this idea of putting more boots on the ground to serve that immigration purpose, it is really, really interesting. Another piece, and maybe Dawn, Leon, you can talk about it a little bit more, is the sanctuary city issue. And I think it was, I forget what state or locality Tom Homan was talking about in the last 48 hours, but it was a sanctuary city, and he said something to the effect of, they're gonna blanket the city with federal agents if the city wouldn't give up the jail records or allow access to the individual who was detained by that local group. It also, I think, plays into the raid planning or the targeting, there was this theory floated among my colleagues, and where prior to the administration taking place, that certain sanctuary cities, if you had two targets for a worksite operation and they were of equal criminality, they were equal culpability, but one was in a sanctuary city, they were more likely to target the one in the sanctuary city. So that fits into their targeting matrix a little bit.
Yeah, and that is interesting. Just to kind of mention, so Tom Homan has yesterday and today, talked about flooding work sites and deportation, and is focusing on having the sanctuary cities cooperate. And this morning I did, and I'll put this in the chat. I did see that ICE updated their sanctuary city 280, their 287G agreement page with all sorts of ways of how you can all participate and whatnot. And I just think it's interesting that they are focusing on that. Leon, anything to add?
Yeah, the only thing that I would add, and is that there will probably be other kinds of pressure brought on cities in addition to the blanketing of with enforcement agents described. I think there are going to be the same kinds of things you've been seeing happen to universities and withholding of funding, for example, and the initiation of other kinds of investigations. Those are things that could be happening to these sanctuary jurisdictions as well, which in turn could put pressure on employers in those jurisdictions in various ways.
So not on that anymore, I'm going to pivot a little bit to the last item on border issues, because this is something that's coming up a lot on a daily basis. I have multiple calls and emails about what's happening at the border when people are returning to the US or coming in for the first time to the US. But the other thing that's more recent about this week is clients sending me articles about the increased presence and some of the military resources that are being applied to the southern border. So could one or all of you kind of speak to those issues as well?
Sure. I mean, we're certainly seeing. Let's talk about the electronic searches for a moment, because this is something Dawn and I have been hearing about a ton, and it's kind of gathered particular steam over, I would say, the last 2 or 3 weeks, where companies are reaching out for guidance on what the rules of the road are if one of their employees is traveling internationally. Incidentally, also asking whether their employees should even be traveling internationally at all. Right now, those who are not, actually U.S. citizens, and we're reminding them that in fact, customs officers do have the right to search the devices, that they need to make decisions about what devices they want to let their employees carry when they travel internationally, and what protections they want to implement with respect to the data that's on those devices. I don't know, John or Dawn, if you know, in fact, empirically, whether there have been more searches at the border, but there's certainly way more concern than I've heard in a very, very long time coming from employers, both about traveling and what they carry. As far as the Southwest border, I'm surprised that it took this long. Of all the things they've been doing, this was sort of the biggest campaign theme. So I would have thought that would have been the first place resources went, rather than the interior. So I'm not at all surprised that that's what's happening. I think the question for me is going to be what that means over time in terms of migration, whether in fact people will just find other routes.
Right, and I think for those who have sponsored populations, I think they're the ones who are the most concerned when they see these news articles. And I think what I've been trying to share with folks and reiterate is that some of this, including the ability for your electronic devices to be searched, has always been there.
Exactly.
It's not something new, right? It's just always been there. We're hearing more about it now for a lot of different reasons. Not easy to pinpoint. But back in 2017, Dawn and Leon actually did do a blog post on searches, electronic searches then, and it's being updated, and you'll see an updated version soon on our blog as well. So encourage you to check that out. But they've always been there. Similarly with kind of what you're seeing in the news with the military presence and the increased attention to the southern border. Again, if you're a visa holder and you're coming in on your H-1B, on your L-1, applying for a TN, that doesn't really relate to you, right? It really just relates to those to more of the other side of immigration with the migration that Leon just mentioned. So a lot of this has always been there. Border checkpoints near borders have always been there. That's not different. I live in Southern California. Coming back up from San Diego, we come across them all the time. So some of these things have always been there. They're just more prevalent in the news right now, and I think that's what's concerning folks. But moving on, kind of turn it back to you, Dawn and John, to talk about kind of what's on the horizon, what we see coming. Some of this I think you've already touched on.
Yeah, exactly. Again, I think we're going to see a lot more on the criminal side. We are waiting for these raids, call them disruptive enforcement actions. They are the government we know. They are bringing in folks from other agencies. And I think really right now, the reason we're not seeing that is just because of their lack of manpower, and the government's the administration's focus on specific, taking out the most egregious offenders first. But I think that's going to change. This notice of inspection are definitely going to be more streamlined. Right now, what we're seeing in the field is what's happening in Boston is very different than what's happening in Washington, D.C., which is different than Chicago or different than L.A. We're getting different notices asking for different things. It used to be under prior administrations that after President Bush, everything had been centralized, and now I'm seeing different things. So it is really important, if you do get a notice of inspection, to work with your legal counsel, because there are some things that we may want to respond to, other things in an administrative subpoena that we may not want to. And because we're seeing right now things being very decentralized, you have maybe more of an opportunity, but I do see them becoming more centralized going as we move further in. I know that that's what they're trying to do. I'm going to skip down to Social Security no match letters. I've got a lot of calls this week about this, the death list that the administration had moved folks that they said no longer had work authorization or were here illegally. They moved them onto normally the list that folks that are no longer with us are on. So employers are very concerned about that. What I'm going to tell you right now is that we have not seen Social Security start with the no match letters. And what I mean by no match is the wages that are reported do not match up to a Social Security, don't match up to the name, or don't match up to somebody who's alive, or other mismatching in the name. We haven't seen those letters in a while, and these death letters that are going out, or updates, are going to employees, not to employers. So I'm telling everyone that's contacting us right now is just stick to whatever policy you would have on addressing no match until the government tells us otherwise. Massa, actually I'm going to throw to you on FDNS visits. Like, just real quick, because you're on the visa side. Do you want to just super
Yeah, sure. I mean, yeah, absolutely. So the FDNS is the fraud detection unit that sits under U.S. Citizenship and Immigration Services. So historically, their focus has really been to validate the visas that have been issued and those employees under those sponsorships. So they often will have unannounced on-site visits, or they'll call or they'll email either the company representative on the sponsorship or the individual directly. And we did see an uptick in this, and we've talked about it on some of our other sessions. We saw an uptick at the end of 2024, maybe in preparation for what they saw coming, maybe as a result of the H-1B modernization regulations that came out that really kind of solidified some of their attempts that all started back in Trump 1 as well. But yes, we have seen an uptick in terms of those on-site visits. So they're coming in to confirm your H-1B worker is doing what they're supposed to be doing, or there is an actual office space there that they're working in, or your L1 worker. They may also be coming on your site. You may not be sponsoring anyone, but you might have a consulting firm who has posted people at your site, or staffing agencies that have posted people on your site that have visas. So they're coming in to check on that. So in that instance, it's also really important. Do you know what your folks are going to do if that person is or if FDNS is coming on site and asking questions? And if they're not your employee, do your folks know what to do? So these are questions people have been asked before, because the number of on-site visits have been so low, but we have seen an increase, and we anticipate we'll continue to see that grow. I don't know if Leon, you have anything on that as well. Yeah.
No, nothing beyond what you've already shared. I mean, I think maybe the one thing I would just say, big picture, is that the kind of Buy American, Hire American
America first.
announcements, announcements that we heard from the first Trump White House, they're looking very different this time around. You're certainly seeing all this tariff activity, but you're not really seeing that sort of antipathy toward foreign sponsored, especially high skilled foreign sponsored workers that you saw in the first, say, 6 months of the first Trump administration. So that, I think that's creating for a different experience, maybe with the way, one, these site visits are looking, and two, also with respect, which we'll probably talk about at a different time, with respect to just adjudication behavior by USCIS. So and that's because I think the energy is being directed to a lot of the other issues that we're talking about.
Very true. So I'm going to move us, pivot us, Dawn, to
Actually,
our next section. Sorry.
just real quick, I wanted John and I wanted to talk quickly about what we think we're going to start to see on the knowledge, what employers, constructive and actual knowledge. John, I'll just turn it to you real quick before we move on to.
Yeah, Dawn, absolutely. And I think this is one of the bigger picture items. If you take the entire ecosystem at a 10,000 foot level, is that the government's going to come in and they're going to start asking questions, and they're going to ask questions of everyone within your ecosystem. And, they're going to attempt to prove actual knowledge. If the employee comes to you and says, I have this letter that I lost my employment authorization effective now, I can't work anymore. Well, you got to do something about it. But also, if you start to get, through different channels, through hiring, through onboarding, through, the supervisor, little dribs and drabs, someone says, hey, I'm worried about being arrested by ICE, so I need an accommodation. I need to work from home. Someone in HR might not know about that. Someone in HR might know that this person's on an EAD, or, it took them 3 times to cobble together documents to complete their I-9. So those, really discrete and otherwise, irrelevant facts, when viewed in a vacuum as they happen in your organization, the government's going to come in and have hindsight. And the government's going to say, well, you should have known, because this, that, and the other thing happened. This person, lacked work authorization, or there was some other issue. That middle manager piece, the rogue middle manager as applied to liability for the entire organization, is going to be really interesting going forward.
Yeah, I totally agree. Same thing with everyone wants to initiate an audit. And, I always say, well, before we initiate an audit, let's talk about what we're going to find. Are you prepared to have knowledge on certain things? So we'll talk about that a little bit later. But no, excellent points, John. Sorry, Massa, go ahead.
Wonderful. Thank you. So as we move on to talking more about some of these programs and what's happening with the administration's decisions to end some, there's compliance challenges. John brought one up. How do you keep your I-9 records updated? What is it that you're going to do with them? What happens if it's caught in litigation? What does that mean for your continued employment and your I-9 verification? How do you plan for this? How do you ensure business continuity, right? How do you talk to your managers? So I'm going to turn it back over, Dawn, and maybe Leon, to talk about some of the TPS background and what's happening.
Leon, go ahead. You can do the overview.
Sure. So there, something that's sort of different, but as threatening as the issues we're seeing with respect to I-9s in respect to fully unlawful, unauthorized workers, are large numbers, and when I say large, into the millions of workers who are in various kinds of temporary statuses that the federal government is now in the process of trying to terminate. And you know, one of the things I always say about immigration is it is almost by definition a working age population. You know, so you take any 100 people, if you're talking about an immigrant group, a very large percentage of those will turn out to be workers. So there's two particular statuses that are being affected. One is temporary protected status, and the second is something called humanitarian parole, which we'll talk about in a moment. Temporary protected status refers to people who come from a discrete list of countries that have experienced some sort of catastrophe. It could be a climactic catastrophe, natural disaster, or it could be some sort of civil disturbance, war, or some other kind of civil unrest in the country that leads the Department of Homeland Security to designate that country for temporary protected status. And among the sort of the larger countries that have had temporary protected status for significant periods of time are El Salvador, Venezuela, Haiti, and it's those last two that have recently been the subject of efforts by the federal government to terminate the temporary protected status designations for those countries. So starting with Venezuela, there were actually two different Venezuela designations, one that occurred in 2021 and another one that occurred in 2023. And there was an effort to, at the very, very last days of the Biden administration, there was a somewhat hasty effort to extend the designations for each of those countries. And those were immediately rolled back within days after inauguration. The Department of Homeland Security issued orders rolling those back. Just talking about the most urgent of the examples would have been the 2023 designation, under which, because of that rollback, employment authorizations would have expired on April 2nd, 2025. So we were having a lot of frantic conversations over the course of March with a number of our clients who were trying to figure out what to do with those employees, in part because in fact, various individuals and advocacy groups filed lawsuits in multiple places in the country. The one that you see here on the screen, Judge Edward Chen, who I think is in California, issued an order pausing the revocation of temporary relief for Venezuelan TPS recipients. This was a big group. This is a group that was about several 100,000 potentially work authorized people who were affected by this. And we've certainly had conversations with a number of clients who actually have multiple what appear to be Venezuelan TPS recipients in their workforce. So now this is extended back out into, I believe it's October of 2026. For as long as Judge Chen's order stays in effect. And this is where this starts getting a little, turns into a little bit of a roller coaster. It's unclear what the federal government is going to do in response. So it may take this up to the circuit. In this case, I think we're talking about the Ninth Circuit, where the federal government, there's a decent chance they will, that actually the Ninth Circuit will uphold Judge Chen's decision. Or, as they did in the case of the El Salvador rendition that many of you have probably been reading about in the papers, they went straight to the Supreme Court and filed on an expedited emergency basis for consideration by the Supreme Court to overturn the lower court's decision. So we haven't seen yet what they're going to do in this case, which means that for now, this group of people continues to have valid work authorization, assuming various other conditions, but as a group overall, this group continues to have valid work authorization into 2026.
April
So,
2nd, 2026, just to be clear. Sorry.
a curveball for all of you. I mean, we're living this day in and day out, and we're looking at all these dates and we're keeping on top of it. But thinking about our listeners, what am I supposed to do, and how am I supposed to keep track of all of this? Like, what does this mean to me?
It's very difficult. I mean, it is something that, anyone that will listen to us at USCIS, John is on a liaison committee, which I've sat on, and, we have contacts. We're constantly telling them. Unfortunately, USCIS is just basically effectuating whatever's, coming down either from Congress or from the administration, and, they're having their own struggles. But what I can tell you is, as you mentioned, Massa, we have a blog, and by the way, I'm very careful about getting information from just general blogs on the internet, because everybody wants to be an I-9 lawyer right now, and every day I'm reading information that may not be 100% accurate. And I'm being serious. You do want to be careful about that. But USCIS has a website, E-Verify, and I-9 Central put out information. And for TPS in particular, they do update, although I haven't seen, we're going to talk about Afghanistan and Cameroon in a minute. I haven't seen that being posted yet. They do update, and they have per country, so you can see like when the auto extensions go through, and all of that type of information. But it is very, very hard. I would just say, you have to keep up to date on it, and be constantly in touch with legal on that, and like I said, review things on the USCIS website. It's not a perfect answer.
No, it's not. And if I-9s are on your desk, if you haven't already favorited those I-9 Central and the USCIS sites pages for TPS, I highly recommend that you do. And they should be kind of your first touch point when there's a question that comes to you. And then beyond that, obviously, if you're working with legal counsel in our team, reach out. And that is kind of what we're doing on a day-to-day basis, because so much is changing. Sorry, John, were you going to say something?
I was just going to say the ask that the government is placing upon HR practitioners, it is immense. And really, if I'm someone who I'm lucky enough to be able to sit and think about this stuff every day, if I am, texting Dawn or contacting Leon at 10:30 at night because some edict came down and it doesn't make sense to me, or there was a string 6 or 8 weeks ago where Dawn and I were game planning, okay, if they come after CHNV, what does it look like? And look at that in a minute, where it was 5 a.m. and I was, up researching these arcane places of the statute. But that's what I like to do. And, that's, I guess.
We're geeks, we admit it, we're I-9 geeks.
Right. Someone said that compliance lawyers are cool again, but really we have to acknowledge that, and we have to devote our resources to it. And as a business person, you really have to say, these are my sources. This is, if you have a foreign national population within your org that numbers in the hundreds, you're obviously going to pay a lot more attention to it, to these issues, than if you have 5 foreign nationals. And we'll talk later about how to identify impacted populations in, go forward planning. But it's all about the resources and really finding the quick way to get to the answer.
To be clear, I think if the federal government expects employers to adjudicate this, and I agree with both John and Dawn and Masa, I think the federal government is expecting employers to adjudicate this. And figure out who is in what status and is from what country and when their expiration date is. That is not something that the I-9 regulations actually require. And that is my way to say that this is an issue that's going to find its way into litigation at some point down the line. But let me say this too, that litigation may come too late. For a lot of employers.
So let's talk about that for a minute. I'm going to throw out, just for the sake of time, just go back on the Haiti. The Haiti one is important because it was the first time in the Federal Register and the USCIS guidance where the government actually said, employers, the Biden administration had given you 18 months. No, we're reducing it to 12 months. And now employers, not only employers and state agencies and anyone else that, that has this relationship to the dates, you have to go back in and you have to change the date. We've never seen that. We've never seen the directors actually come. So that was, they literally say, go and change the I-9, make Hades August 3rd of 2025. So skipping over to what you were saying, Leon, okay, there they told us, but we can go to the next slide and talk about parole and things where they haven't told us. But just broadly speaking, I think for employers, it's not just whether or not they're afraid, or we're afraid that we're going to have the wrath of ICE coming in and saying, oh, you have an illegal worker whose work authorization expired. Majority, if not all of my employers, want to do the right thing, right? They feel badly. They want these folks to continue, but a lot of them, from an operational standpoint, that's where they're struggling. They need to manage, how many Haitians are we going to lose, in August? And for this parole, which Leon, you can certainly introduce right now, it's very, very hard. So it's not necessarily the litigation, that is going to be that the employer didn't know or we didn't have knowledge. In these cases, employers are trying to figure it out, and it's very, very hard to identify. So Leon, why don't you start off?
Yeah, although I will say sophisticated employers are trying to figure it out. There's plenty of, mom and pop businesses out there that are just doing the best they can.
Tony's Pizza, right? The Tony's Pizza, who I talk about all the time. It's a pseudonym, but they are concerned, right? Because they're concerned, are they going to lose, the two Venezuelans that do the baking in the morning, and should they be replacing them, if someone's going to come and get them? So that it's from the biggest to the smallest, I think. But
yeah, and I know our role here is to sort of give practical guidance to our listeners. Part of the practical guidance is there is going to be a litigation roller coaster on even these issues as well, and things are going to change and change again on the question of what are employers' responsibilities. I think care at the end of the day is going to be what is required, and to do what you can to understand who your workforce is, what their status is, when that status terminates, to the extent that those things are actually knowable, and they're not always going to be knowable.
They're not, or absolutely not. It's going to be very hard.
So let's talk about parole. What is parole?
So parole is a type of immigration relief that allows for the discretionary admission. It's when they enter and when they leave is completely in the discretion of either Customs and Border Protection or U.S. Citizenship and Immigration Services. Discretionary admission to the U.S. For some humanitarian purpose. This was designed in the first instance as as an individual determination. So the classic case we always used to talk about, somebody needs an organ transplant. They need to get into the United States really fast to get that organ transplant. So humanitarian parole becomes the rapid path to get them into the U.S. for their surgery and for their recovery, and then they're expected to go home at the end of that period. But in fact, it's come to be used, the legal provision has come to be used more broadly, and now there are what are called categorical parole programs, which means parole programs that in fact cover thousands, hundreds of thousands, and in some cases even millions of people from particular countries who have particular characteristics, and who the federal government decides that as a group, those are people that should be admitted to the United States on a temporary basis. So there is a particular parole grant that is now was recent of those categorical parole programs that was recently canceled by the federal government, and that is the CHNV program, which stands for the Cuba, Haiti, Nicaragua, Venezuela program. And these countries have in common that they are countries that are in some way countries that historically have been difficult or impossible for people to deport their nationals back to those countries if there is a basis. And so recognizing this, and in light of the massive migration to the southwest border that has been occurring now for over a decade, the Biden administration implemented a program under which 30,000 people a month from these countries, subject to other conditions, would be admitted to the United States. Unlike the temporary protected status population that we were talking about a moment ago, all of whose authorizations expire on a single knowable date, the CHNV parolees' employment authorizations are all over the board. They can expire at any time. So there's no way that you can look in the EAD and actually know, even if you know what country they're from, actually know specifically whether they're part of the CHNV program or not. Nonetheless, Department of Homeland Security revoked the CHNV parole. They sent out these notices. I think we may have a picture that Dawn's going to show or somebody's going to show in a moment of what those notices look like. But on April 10, 25, Judge Indira Talwani in Boston issued a statement of her intention to stay the implementation of the Federal Register notice that announced the termination of the CHNV program. Otherwise, the termination would have gone into effect on April 24th, 2025. And all of those work authorizations, although you wouldn't know which were those work authorizations or not, would have expired on April 24th, no matter what it actually said on the card. So that has now been stayed by Judge Talwani. Again, we don't know what the federal government's going to do. Are they going to go to the First Circuit, where they will, reasonable chance that they're going to lose in the First Circuit? Or will they go straight to the Supreme Court, where their odds are better? And they can go to either place on an emergency expedited basis. They can try to do that. Generally, courts will defer when the federal government comes in on an expedited basis. The problem is that they're already breaking records with how many cases they're trying to take up to courts of appeal on an expedited basis. So it's unclear when potentially they're going to run out of gas and just simply be unable to take these cases on an expedited basis. So we don't know whether this is going to stick. We don't know for how long it's going to stick. And we don't know what ultimate decision is going to be made by the appellate courts. What it means for all of you for now is that the work authorization for these folks remains in effect. There's been no guidance once that work authorization starts expiring. Once there is a sort of a final outcome to this as to how that final outcome is to be implemented, especially if it is that the termination of the program goes into effect, how exactly you're supposed to know who of your workers are in these categories. So far, there has not been guidance from DHS as to how you're supposed to sort out who those people are.
So, and that does take us back to how are employers supposed to act on this and who is getting notification? Because it's not the employer. The government doesn't know which parolee is working with which employer.
So I do want to just mention that before the stay, in our conversations with USCIS, we were advised that they were attempting, no promises, but they were attempting for E-Verify employers to cross-reference those folks that entered under parole and that were run through an employer's E-Verify system. They were going to notify, this was going to happen on April 25th, after the 24th, after the work expiration expired. It would not necessarily mean that the employee was still with you, right? Because they could have been to 3 different jobs and, been run at through E-Verify in 3 different places, but they were trying to do that. And when I said that, it is difficult for USCIS to implement these things. I mean it, right? Because they're trying every which way. But you're right, Massa. There is no perfect way, and some employers will. If you're an E-Verify employer, you must keep copies of employment authorizations. The majority of these people presented employment authorizations, right? And that will have the category code of C11, and they'll have one of the 4 countries associated. And even then, they may not be CHNV. They could be here on that medical parole that Leon answered. John, can you talk a little bit, before we skip on, because you're in the thick of it on the electronic I-9 side of this. That I guess would be kind of best case scenario, that you have a copy, that you're even you're coding C11s. You can run a nice report for your customers. Talk a little bit about that. What struggles we're seeing.
So I think from my perspective, and certainly not an advertisement for our group, but from my perspective, I looked at this and, I said, okay, I can't get you because, we have not for only the past 3 or 4 months, we've recorded category code as part of our service and made that visible because we do it for other reasons. I've told people, we can get you a nice clean report that has where EAD was used and where expiration date is one of like the 26 or however many are impacted. I can drill you down. My job, really, if I can't get you the exact answer, it's to minimize your effort. So instead of going through 50,000, EAD, I-9s that were completed with EADs, maybe you say, all right, I have 3,000 to actually look at. That's the TPS issue, which is much cleaner than the CHNV issue, which, I told someone a couple of weeks ago, I'll get you a report of all of your EAD cases, or your I-9s completed with EADs, but even then, what are you going to do? And to this group, really, what do you do when I see, oh, C11 Venezuela? I don't know if, to Leon's point, that person was paroled in for an organ transplant or under CHNV, and I don't know how E-Verify itself would know. Because I assume, right, I don't know what information is being sent back and forth from CIS benefits to E-Verify, but the
I think
coding
they were going to layer. That was going to be their job. They were going to layer
Well,
over.
we also know they're sending notices to the wrong people.
Wrong people, right?
So
and what
there's not a whole lot of
exactly.
confidence there, right?
Whether or not we can trust that information, I don't know, and whether or not they can trust that information. But that's, again, this was an idea. So sorry, John, didn't mean to interrupt, but you're.
I was just going to say, every employer is going to be different. We've said, there may be some employers who operate in highly regulated spaces, and they say, listen, I have to comply with this. My cost of non-compliance, because I'm in a heavily regulated space, or I'm in Florida, where I know the state or the federal government may come after me, and they may pop my business license, and then I'm out of business. That cost of compliance far outweighs the cost of replacing a body or terminating someone when you might get really good legal counsel that says you have an argument the other way. Flip side, if I rely on large swaths of CHNV employees or EAD holders, whatnot, that my cost of compliance may put me out of business. So it's really along that spectrum. And I think getting into our hardcore takeaways at the end, this is the termination notice for parole. And I think we have a second, right, Masa?
Oh, yeah.
Yes, we have the CBP one. Mm-hmm.
And then rolling into, what our firm takeaways are. Dawn, if you want to, Masa, if you want to advance, and then Dawn can lead us off.
Thanks. Yeah, what can you do right now? It's overwhelming. Like I said, I've been practicing a long time, and every day I wake up with like a sense of dread. And I do, start reading at 5 a.m, and sometimes texting John. He has a new baby, so I figure he'll be up. And we're going back and forth. Did you see this? Did you see this? It is. There has to be a filter, and employers can only do so much. But like John said, I think in terms of planning, it depends upon what your goals are and who you are. There is no one size fits all piece of advice. And if you're, just getting your advice from an alert or an update, it's probably not the right one. Go ahead and subscribe. Make sure you know who you're getting your advice from and whether or not it is accurate. Take a look at your Form I-9s. Several years ago, I-9 compliance planning was not so important. I knew that I was very low down on the HR list in terms of priorities. My practice wasn't that important unless you were in trouble. If you were being investigated, it was a different story. But now, having an understanding what your I-9s look like, it's important. It is shocking to me that some employers still do not have I-9s, and that $4 million fine that I shared from a friend of ours, he told us that the company just didn't have I-9s. So if you don't have an I-9, now is the time to get an I-9. You're going to have a late completion, and that's still a finable offense, but at least you're going to know whether or not you have workers that are authorized, and you'll be able to complete it. Now, in terms of what else to do, I'm not asking everyone to run out and to do an I-9 audit. I think doing an assessment, doing an inventory, do you have an I-9 for everyone? Does everyone have work authorization is super important. But having the same people who made the mistakes do an audit may not be the right thing to do. Also, if you're going to do an audit and you're going to uncover, fraudulent documents or concerns, are you able to operationally act on it right away? So take a look at your I-9s, then also look at your processes and your policies and your procedures. Many folks during COVID signed up for electronic I-9s, and they did not understand that electronic I-9 vendors have a whole set of regulatory requirements and guidance. Not enough information from the government, but there is enough there to know that there are certain things that have to be present in an electronic I-9 system in order to be viable. And I feel very badly. Several times a week, I have to tell employers that I have a concern over their electronic I-9 system and whether or not, it has an audit trail, or whether or not its electronic signature meets the regulations. What does that mean to you? That means that you may have all your I-9s in a system that have not created them. What does that mean? That means you don't have I-9s. It's like you're missing an I-9. That is the way the government treats this. And I can tell you that with the NOIs that we're receiving, if nothing else is present, they are asking about the electronic I-9s. And each and every inspection we have, they're focused on the electronic I-9s. They know that it's kind of an easy way to fine and to have penalties. So they are looking. So super important to be aware of that. In terms of policies and procedures, again, speaking to your folks, if you have a sponsored foreign national population, make sure your immigration folks are involved in your processes, and also make sure that you, as I said earlier, that you have a way in which to handle law enforcement coming on. So it could be ICE, it could be FDNS, what Masa was mentioning. It could be other law enforcement agencies, but we don't want people to panic. John, Leon? Okay.
Sorry, and I was just add what we haven't noted here is involve your legal department, involve your outside counsel.
Yes.
Make sure your conversations and your reviews and assessments of your current I-9s are privileged. There's often we come into something where an audit was done by HR, but they didn't involve legal, they didn't involve outside counsel, and that can create more issues and more liability for you. So if you're HR and you're not coordinating with the legal department, it's a good opportunity to do that, and this would be the area where I would highly encourage folks to do that. And then just in the interest of time, in our last 3 minutes, and we're right at the end, what is on the horizon, if we can get some thoughts from the three of you?
I think a lot, right? I think, and it's really unpredictable. We know that the enforcement is going to increase. We know that the kinetic energy of enforcement will increase, but there's a host of regulatory changes that are on the chopping block. This idea of employment authorization extensions, things that they can run through the Federal Register, the termination of the alternative, Form I-9 inspection procedure, which I think was really, really hot around the time of January 20th, in my opinion, has sort of cooled. So maybe,
let me explain what that is, because we worked so hard on that. That's the remote I-9, basically virtual, where you could do your I-9 if you're a participant in E-Verify. You could actually do your I-9 on video, and that was considered physically inspecting. So you would see the person, you could look at the documents, and we worked really hard for that. And there was some discussion. I think it's still there, but they're very busy with other things that they may be taking that away.
Right, exactly, and far be it. Shortening the list of acceptable documents, that was something I heard bandied about in December. Things they could push through the regulatory process, and especially given the not so recent comments about disregarding notice and comment rulemaking for certain immigration issues. Congress could act. I'm interested, Leon, what are your thoughts on a nationwide E-Verify mandate in this Congress?
You know, it's interesting. We're starting to hear, and I don't think I'd heard it before this year, about Republican opposition to the E-Verify mandate, and it's coming, among other things, from rural states where sort of the reality of what this might mean is dawning on certain kinds of employers. And so, I think I was talking to a reporter recently who was telling me, "Look, there was an E-Verify bill from some congressman I'd never heard of. What do I think?" And I said, pick a topic, and there's a bill every single week on that topic. And those bills are meant to go nowhere. They're just an opportunity for that legislator to flex and say, look what I'm doing. And so I think E-Verify is one of those things. I think there's been a lot of posturing. I'm skeptical about whether this is actually going to turn into something national.
But watch your state. Seyfarth has a 50-state survey for our clients
Sure.
that have access to what is out there, what's already mandated in the mandatory states, and then also we can help you with what's coming down the pike, because I do think that states are going to move.
Well, thank you all. We're at the hour. Hope this conversation was helpful to those of you who are trying to manage your workforce and manage business continuity as you're seeing all of these changes taking place. We'll share CLE credit for the session code is SS5000. Again, that's SS Seyfarth 5000. And the SHRM activity code is 26-E6X, F as in Frank, G as in George. Again, that's 26-E6X, F as in Frank, G as in George. Want to thank again everyone who joined us today to listen. Hope you found this helpful. Thank you to our panelists. Appreciate you sharing your thoughts and insights, and we'll look forward to seeing folks back next month.